Hello, and welcome to JD Advising's California Bar Exam Essay Guide. The goal of this guide is to help you find an effective and efficient approach to the California Bar Exam essays right from the very beginning. This guide will help you feel confident on test day so that you can conquer the essay portion of the California Bar Exam. If you have any questions about this or other resources we offer for the California Bar Exam, please don't hesitate to contact us. Some of our other resources include a California Bar Exam prep course, private tutoring, essay feedback, and one-sheets. If you reach out to us, we'd be happy to speak with you about the resources that can best help you prepare for the California Bar Exam. We hope you enjoy this guide and good luck on the exam. In this video, we're going to talk about the next subject, which is real property. This is often viewed as a difficult bar exam subject, and it appears on both the multiple choice and the essay portions of the exam. I'm going to give you some tips for real property essays that hopefully make it a little bit more manageable for you. First, let's discuss how real property is tested. Real property is usually tested on its own and not in a crossover question. There are some topics within real property, though, that lend themselves to crossover questions. For example, the issue of nuisance could be tested in a real property/torts crossover, or eminent domain could be tested as a real property/constitutional law crossover. However, when these topics have come up on essays in the past, California does not label them crossover questions, but instead they just label them real property questions. Real property is tested about once per year, or on average, every other administration of the bar exam. The California bar examiners have never instructed students to apply California law on a real property essay, so you can apply the same general law on the real property essays that you learned for the real property multiple choice questions. Next, let's discuss the highly tested real property issues. Several of the highly tested issues in this subject include joint tenancies, landlord-tenant issues, assignments and subleases, easements, and covenants and servitudes. This may seem like a lot of issues, but if you can memorize a basic rule statement for each of these common issues, you'll be able to quickly and efficiently discuss each of those issues in your answer. First, let's start with joint tenancies. Some of the things you'll need to know regarding joint tenancies include how it is created, how it is destroyed, and the rights and duties of co-tenants. So to create a joint tenancy, 4 requirements must be met. These are usually referred to as the 4 unities. The joint tenant's interest must be created at the same time. They must take under the same title. They must have an equal interest in the property, and they must have equal rights to possession. Next, there are 4 ways to sever a joint tenancy. Once a joint tenancy is severed, it becomes a tenancy in common. The mnemonic to help you remember the 4 ways to sever a joint tenancy is GSAM, G-S-A-M. That stands for give it away during life, sign a contract for sale, actual foreclosure sale by a judgment lien creditor, and execute a mortgage in a title theory state. Finally, both joint tenants and tenants in common have certain rights with regard to their shared ownership of property. This includes that they have equal rights to possess the entire property. They have the right to profits earned from the property if there's been ouster, depletion of natural resources, or if the profits come from leasing the property to a third party. And they have an obligation to make contributions to the upkeep of the property. Specifically, each co-tenant is responsible for his or her portion of the taxes and the mortgage payments, as well as any necessary repairs to the property. The next topic is landlord-tenant issues. Some of the laws you should know within this topic include the different types of leases. So for example, tenancy for years, periodic tenancy, tenancy at will, and also the duties of the landlord and the tenant. The tenant really only has one duty. He has to pay rent. If the tenant does not pay rent, the tenant has breached the lease and the landlord can evict the tenant. In some jurisdictions, the landlord can also sue the tenant for damages, for example, for the remainder of the rent payments for the duration of the lease. But many jurisdictions require the landlord to mitigate these damages, meaning that the landlord often has to try to rent that property out to someone else before just turning to the evicted tenant to try to collect that anticipated rent money that's still due under the lease. The landlord cannot evict the tenant unless the tenant fails to pay rent, like we discussed. And if the landlord does wrongfully evict the tenant, the landlord has breached the lease. If the landlord wrongfully evicts the tenant, the landlord will have breached the covenant of quiet enjoyment. There's a few different ways a landlord might evict a tenant. There could be total actual eviction, partial eviction, or constructive eviction. I want to discuss constructive eviction because this is the type of eviction that is frequently tested. Constructive eviction occurs when three requirements are met. First, the landlord has done or failed to do something that made the premises uninhabitable or unusable. Second, there's a substantial interference with the tenant's use of the property. So, for example, the heat doesn't work in the winter. And third, the tenant abandons the premises after a reasonable time. I want to emphasize this third requirement. In order to claim constructive eviction, the tenant must actually leave. So if the tenant complains to the landlord that the heat isn't working and the landlord does nothing to fix it, but the tenant stays and just gets some extra blankets, the tenant cannot claim constructive eviction because he hasn't been evicted. He did not actually leave the premises. Another issue that I want to discuss also has to do with leases, and this is the topic of assignments and subleases. This is an issue when one person signs a lease and then a second person takes over a portion of that lease or the remainder of that lease. I actually had this issue myself when I was in college. I transferred to a new school in the middle of the school year, so all of the off-campus housing was already rented out at that campus. Well, I was able to find a student who was going to be studying abroad for the winter semester. So even though she had signed a lease for the entire school year, I took over her lease for her for the winter semester while she was gone studying abroad. On the exam, the question is generally whether this is an assignment or a sublease. So an assignment occurs when a tenant transfers all of his interest in the premises. That means that there is no time remaining at the end of the lease when the original tenant will be returning to the premises. If the landlord does not receive rent payments in a assignment situation, who can the landlord sue? Well, they can sue either the assignor or the assignee. The landlord can sue the assignor, the original tenant, under a theory of privity of contract, and he can sue the assignee, the new tenant, under a theory of privity of estate. A sublease, on the other hand, is where the tenant transfers only part of his interest. So, for example, a tenant signs a lease from January through December, but the tenant is going to go on vacation for June and July and find someone to take over the lease for those 2 months. This would be considered a sublease because the original tenant is coming back to the premises in August and is going to finish out the remainder of the lease. So he's not transferring all of his interest to the sublessee. In a sublease situation, if the rent is not paid, who can the landlord sue? The landlord can only sue the sublessor, that's the original tenant, under a theory of privity of contract or privity of estate. There is no privity between the landlord and the new tenant, so the landlord cannot sue that sublessee. However, if the landlord sues the sublessor can then sue the sublessee because there is privity of contract between the sublessor and the sublessee. The next topic that we frequently see tested is easements. An easement is a non-possessory interest that gives someone the right to use the land of another. So for example, let's say a man owns some lakefront property. A woman lives across the street from him. She does not live on the lake though. The man gives the woman an easement that allows the woman to cross the man's property whenever she wants to access the lake. This would be considered an easement appurtenant because it benefits the land of the woman who lives across the street. If the woman were to sell her land, the easement would transfer to the new purchaser. So the easement goes with the land and it is not personal to that woman. The tricky part about easements is that they have to be properly created. One way to create an easement is an express easement, which is going to be in writing. There is no such thing as an oral easement. So if the man just said to the woman, "You can cross my land whenever you want," this is not an easement. In fact, it's actually a license, which does not have the same transferability as an easement. Another way to create an easement is by prescription. There are 5 requirements of an easement by prescription. Use of the easement must be continuous, hostile, actual, open and notorious, and continue for the statutory period. Let's go back to the example of the man on the lake. Let's say the man did not give the woman permission to cross his property to access the lake. However, for the statutory period, she crosses his property every morning to go down to the lake. He sees her actually walk across the path down to the lake every morning, but never says anything. After the statutory period, it is possible that the woman has an easement by prescription. So if she were to sell her property, the purchaser of the woman's property would acquire that easement access to the lake also. The final issue that I want to mention here is real covenants and equitable servitudes. Covenants and servitudes restrict how an owner can use his land. They are written promises to do or not do something on the land. A person would sue under a theory of real covenant if the person wants to recover money damages. They would sue under a theory of equitable servitude if they want to obtain equitable relief, like an injunction. For example, let's say 2 neighbors have a shared driveway, and they agree to keep that driveway in good repair. This promise is written into their deeds, it is recorded, and it states that it is intended to bind not only these 2 neighbors, but also any successors who purchase the property from either one of them. One neighbor sells his property to a purchaser. The purchaser fails to keep the driveway in good repair. The other neighbor wants to sue the purchaser. She might try to sue under a theory of real covenants to collect money damages, or she could sue under a theory of equitable servitude to obtain an injunction requiring that purchaser to repair the driveway. Let's talk about the requirements of each theory. To sue for a real covenant, the neighbor would have to show privity between the original parties to the contract and privity between the neighbor and the purchaser. They have to show that the original promisors had the intent for the covenant to run with the land, that the purchaser was on notice of that covenant, and that the covenant touches and concerns the land. Here, there is no horizontal privity between the 2 neighbors who made the original promise to one another because they're just neighbors. Usually, you need a grantor-grantee or landlord-tenant relationship to establish horizontal privity. There is, however, vertical privity between the seller and the purchaser. Also, the neighbors did intend for the covenant to bind future landowners, which means that they intended for it to run with the land. The purchaser was on notice of the covenant since it was recorded in their deeds, and the covenant touches and concerns the land because it is something that makes the land more valuable or more useful. But because one of the elements is missing, since we don't have horizontal privity, she cannot get money damages through a real covenant theory. However, she could probably get an injunction. An equitable servitude has the same requirements as a real covenant, except no privity is required. So as we already discussed, she can show touch and concern, intent, and notice. And since there is no privity requirement here, it doesn't matter that she can't show privity. Therefore, she could likely obtain an injunction. The next tip for real property is to be aware of how real property issues are tested. For example, often when assignments and subleases are tested, they're tested with a real covenant or equitable servitude issue. We have frequently seen the examiners test whether a non-assignment or a non-sublease clause is enforceable, so be aware of that issue as well. The 4th tip is to learn the distinctions between closely tested topics. One of the things that makes real property difficult is that there are nuanced distinctions between different legal concepts that can often be hard to grasp. For example, make sure you know the difference between a joint tenant and a tenant in common. Also, know the difference between partitioning a joint tenancy and severing a joint tenancy. You should know the difference between a tenancy for years and a periodic tenancy. You should also know the difference between the implied warranty of habitability and the covenant of quiet enjoyment. You should know how assignments and subleases differ. Be able to explain real covenants and equitable servitudes. And finally, know how pre existing uses in zoning cases differ from variances. The final tip for real property is to practice. Even if you're struggling to fully comprehend some of these difficult concepts, practicing and looking at sample student answers will definitely help you see what information you should be including in your discussion of each of these issues. We recommend that you practice the February 2021, October 2020, February 2019, and February 2018 real property essays.